Spanning across cultures, it captivates our collective attention. It raises profound questions and has us all arguing about the nature of morality and justice. With lives hanging in the balance, these high stakes are the crucibles of intense scrutiny. The weight of justice in these legal arguments and the ultimate decision to take a life converge. Once upon a time, in a town named Moscow, Mosquito, in a town, Moscow, in a town named Moscow. A fortunate streak, no reported murders in 7 years. Some said it was too good to be true, and others said luck could be on one's side, even in the most unlikely circumstances. However, fate had a different plan in store for the shady and corrupt police department in Moscow. One day, they finally encountered a murder. Well, not just one, but 4. A town shaken to its core. The police found themselves facing a perplexing and challenging investigation. A knife sheath with a viable touch DNA print. They allegedly held on to this information, refusing to reveal it to the public.
The fact that the law enforcement knew who he was from the get-go and didn't warn us to keep Jasmine home from school, that just, I'm just beside myself.
And Jasmine was at WSU for the whole 7-week period.
Yes.
From the murders to the arrest. She was there the whole time.
Yes.
So if the police are withholding information, it would prevent the defense from investigating those false positives or challenging the validity of the match.
It allows us to make decisions about how we might cross-examine this evidence, how we're going to confront this evidence. And he also made it crystal clear to you that it is scientific evidence because we began with a surface trace sample that has been extracted to DNA. A portion of that DNA went to an STR test, and a portion of that test went to some other lab that we really don't yet know. There's been discussion in pleadings about whether or not it's Othram lab or some other lab. I think kind of the general knowledge is that it's Othram, but we really don't even know that. So this original scientific sample from this surface trace DNA has been the product of multiple scientific experiments that we are entitled to have the underlying data on. And if we don't have that information, we are not going to be able to be effective attorneys for Mr. Kohberger.
So, of course, every decision in this case could mean the difference between life and death, so they're kind of all a big deal, but I would say that the DNA issue here is going to be the biggest deal because obviously there is a lot of missing evidence according to defense, and we saw the prosecutor get pretty upset stating that this evidence doesn't exist, and then defense stated that she would not concede that it didn't exist because it exists.
Make sure I understand this. So you have all the information from the labs and all that as regarding the STR. Is that right?
Well, Judge, with the exception of all of the emails, which was one of the things that we were having some discussion about. So we have some emails that we can tell there were other emails attached that weren't, or attachments that are not there, and we have blank pages. And so the solution to that is simply order it. And then they'll take that to the Idaho State Lab and the FBI lab that's been involved and tell them that we need it all, and then we'll have it.
If it exists. We've had a couple of arguments about that already.
If it exists, and I'm not willing to concede that it doesn't, Judge.
And I understand that. I understand you're asking that. And I'll have some questions for the state too. Because they're arguing that it doesn't, whatever happened with the genealogy DNA doesn't have much bearing, has no bearing on the case.
Oh, well, right, that's their whole argument. That's why you had 4 witnesses today to explain why that is so critical. So that's a different argument than whether or not we have all of the Idaho State Lab and FBI Lab STR emails and the emails that discuss genetic genealogy. Because we understand that they've said you shouldn't get anything related to genetic genealogy. But what we're also telling you is that we don't believe that we have all of the emails related to all of the DNA evidence related to STR. Related to STR. And if you enter an order, then the labs that are involved, it'll be clear to them that they've got to produce that.
You're suggesting, hey, it might be just fine. But you need to examine that to determine that it was just fine.
Are you talking about the genetic genealogy?
Yes.
There's the possibility of both. Honestly, I don't believe that it probably is just fine, Judge. If you're really asking me, we're having to fight so hard for this, and we have someone who's just testified who has worked for law enforcement that improper searches have been done. So I can make the assumption that it was done correctly. I can make the assumption that it wasn't done correctly. If it was done correctly, we probably wouldn't be fighting this hard about it. That's my assumption.
She states that many of the emails from the lab to the prosecution are missing, and some of them are missing attachments, and other ones are just missing emails from the thread. So the entire thread wasn't disclosed during discovery. They are still missing that. That's a completely separate order from whether or not the genealogy DNA is a part of discovery, which of course it should be. And prosecution is so annoying. They come back all the time with, it's nowhere in the statute. Like, yeah, I mean, the statutes assume that you have the basics down, like, legit. Did you not catch that part? So Ann Taylor's forced to constantly be like, we're not stating it's in a statute. We're stating it's missing, and obviously emails are a big deal. Obviously, investigative genealogy is a big deal. So to me, something important here is that they are missing the original link, the original profile that was pulled from this trace DNA in order to finger the suspect. In other words, they literally don't have the beginning of this tree, the very first profile that was pulled to make allegations against their suspect. Arguably the most important branch or root to the tree, right? One of the experts that has been brought in to communicate to the judge that, hey, look, there is this illegal thing that we could do in order to view a larger database than those who have opted in for forensic profiling in the police database. So people who have allowed the investigators to look at their DNA profiles while they're completing forensic analysis for law enforcement work. Well, instead of doing that, you could just steal your patsy's DNA from the trash can. Or if he doesn't throw his DNA in the trash can, or you just happen to not be able to find those traces and you wanted to do something illegal and you lived in Moscow, you could take that DNA profile and upload it yourself to the MyHeritage website. So this MyHeritage trick that they are referring to, or the workaround that she refers to because they don't want to refer to what actually could happen. But the workaround that she says you have to know what you're doing, they have to know that they're doing this, it's not done by accident, is that they upload this as though it were their own genetic profile. So they donate this DNA to MyHeritage or whatever other lab, and they get to see genetic matches that haven't opted into law enforcement, because in this realm, they're not just viewing a modified version for law enforcement. Now, this would be an illegal way to go about getting the evidence. And great old John Judge over here, he goes,
But let's just say, for the sake of discussion, that FBI went around the rules. Does it have any impact?
It does. It does for a variety of reasons. It's going to have an impact on the method of cross-examination. As a preliminary matter, it's probably going to result in a motion to suppress based on an improper search and privacy rights. So we're going to have pre-trial litigation.
Whose rights would be violated there?
Mr. Kohberger's rights. But Judge, we can't make a decision about who until we know what the raw data is and what it says.
Sure.
Right?
Well,
and then they legit cut out what the attorney was saying on court TV. I was yelling at the TV like, what the hell? This is the good part. And I'm blown away that this is his reaction. It is totally not a good sign. What do you mean, then what? Like, yeah, it's a problem. Whose rights does it? Oh my God. If the law enforcement officer were breaking the law while he were enforcing the law, would it be a problem? Yeah, it'd be a problem. So we got to peek into a little bit of the affidavit that was completely redacted from our review that Ann Taylor put in, and that was through prosecution's reaction and response to that affidavit. And that was to say that it didn't matter that one of the grand jury participants, one of the grand jurors, wrote or checked the box that they could not speak English. So prosecution says that's no big deal. Obviously, if they could fill out the paperwork, it didn't matter. And it was just a mistake or a typo, essentially, and that defense is pulling at straws. Defense brought up in this actual last hearing that there were less grand jurors present than what was on the judge's order for the grand jury indictment process. Prosecutors argue it's not in the statutes. And defense is actually asking for an evidentiary hearing about all of the discrepancies that happen in the grand jury process as a whole. So it was really stacking up. That one of them said they didn't speak English. They said that some jurors were asked if they committed crimes and others weren't. Prosecution bit back and said it didn't matter because the grand jury that I guess was the source of concern for defense here was someone who had merely committed a misdemeanor. So it wouldn't matter because only a felony would prevent someone from serving on a grand jury. Well, Ann Taylor in this hearing has brought up a few other things, stating that some of the questionnaires were just completely different, that discrepancy is completely ignored or not specified. And again, prosecution's argument to this is it is not in the statutes that any clerk or that they should have to keep up with such a thing or make sure such a thing is orderly. And the judge kind of dismisses this out of hand in the hearing. I don't know if he will actually file an order for that. We will see. It is not on the website as of the time of this recording, but kind of dismissed that out of hand. Now, the particular motion that the judge kind of rescinded is the order for the stay that he had given defense. And it kind of annoyed me that all of the news stations were like, judge denies order for stay. And actually they were sort of both parties, and didn't object to this. Both parties were sort of conceding that, if the judge is dismissing the grand jury hearing that Ann is asking for out of hand, boom, essentially the stay had already served its purpose. Obviously, probably Bryan Kohberger is the most anxious to get the show on the road of all, I'm sure it was super enjoyable to sit there and hear the prosecution talk about all of the witnesses and the way that they would be affected if Bryan Kohberger had any stay that he were looking for in the process in order to defend himself from death. No need to bombard people with an interruption in their schedule and whatnot. It would definitely suck for the parents, but goodness, one would hope that anyone would want to afford a defendant that opportunity. Obviously, anyone with a brain is going to agree with defense here. If it was all above board, they would just put it on the table. And to add insult to injury, prosecuting attorneys Bill Thompson specifically stands up and asks that he not be able to use any alibi defense, including cross witness testimony, without Anne further specifying what witnesses she wants to cross-examine. So they are definitely intending to prepare the witness that Anne intends on cross-examining in order to further secure their driving alibi defense. Anne says that she knows everything she knows for now, and then he says, well, quite literally, that is what it is intended to prevent, and they want to go a step further, okay? They're not just saying that Anne has to play by the rules, but they're asking the judge to create an order now which would prevent the defendant from presenting any alibi defense that they haven't disclosed at this date or at such and such date, so whatever the order would say. So by such and such time, they are ordered, that if they don't disclose it, blah, 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 blah. It's so weird because, this is like a weird Idaho thing. Most states don't make you give much more past like the literal exhibits that you're going to show or the basis and argument, which Anne has already presented here. And that would be constitutionally in a federal court what is required of a defendant. So this is a weird Idaho statute that Bill Thompson is standing up and arguing that Anne has not effectively completed at this point, and he wants an order from the judge preventing her from entering any evidence that is not Bryan Kohberger's testimony itself, because every defendant has a right to take the stand in their own defense or take the stand in their trial, and there's no specific statute that the prosecution can use in order to prevent that. So they concede that he can say whatever he wants and that they're not asking about that, but they specifically want him to state what witness they plan to cross-examine in order to back that testimony up. And essentially Judge agrees with prosecution and tells Anne that she will need to disclose what witnesses she plans to cross-examine in that context. So maybe we'll get to find out a little bit about what initial person is going to be named there. That would be interesting. So I only recently even found out that some of the warrant which was undertaken that day at Bryan Kohberger's home was given to media, or this is what they disclosed, and it definitely warrants a second look because...
Talbot, the bedroom door is locked. You want us to boot it?
Yeah.
And we didn't boot it because the keys actually worked. What?
Oh, sweet. Oh, even better.
It's locked because there's only one on.
Later today, we're gonna.
I'll talk later. Yeah. And I'm still.
Thanks, guys.
I'm still recording unless you don't want me to. I'm just gonna read the warrant. Well, I'll go inside.
So they'll do the standard steps now. They'll come in, they'll do all the photographs, and then they'll set up the 3D scanner. So.
Okay.
I don't want to do anything for it.
I'm gonna turn off my camera because.
Like, I'm gonna quit recording because quits recording. Like, what the fuck was that? And it was noteworthy to me that in previous motions that I was reading, I noticed that defense attorneys were highlighting cases from the Idaho case law, which discuss not having a search warrant signed by a judge during the search process, which should make us wonder about this process altogether. And for sure, we should be wondering about that scientific investigatory genealogy work that the prosecution is still wanting to hide. Because I guarantee you there's going to be something good there. And I guarantee you defense is probably correct there. If there were nothing to hide, they would give it up. And they won't.